Good morning and welcome to an oral argument session of the 5th District Court of Appeal. We're here at the 10 o'clock time slot and we have one case on the docket. And let me introduce myself. I'm Rand Wallace. I reside in Seminole County and I will be presiding over this case. I have also joining me from our court, Judge Dan Traver, who was from Orange County, and Judge Mary Alice Nardella, who's also from Orange County. I just ask when you're presenting your case, if you're not speaking, just make sure that you have your microphone on mute, and definitely let's mute any devices that we have that may make noise in the background. And I will assume that the appellant wants 5 minutes for rebuttal.
That's correct.
Okay, super. Unless you tell me differently. So Ms. Pohl, then you have the floor.
Thank you, Judge. May it please the court. My name is Beverly Pohl and I represent the appellant in this case, the Frederick Christensen Family Trust. In 2005, the legislator enacted a complete overhaul of the statute governing limited partnerships in Florida. And one of the big changes to that overhaul was the creation of appraisal rights for limited partners in the event of a merger or a conversion to a different type of business entity. Those appraisal rights are set forth are discussed, I should say, in a series of statutes, but I think the key statute for our consideration here is 620.2114. Now, the parties have focused on Section 1B, which says that an appraisal event occurs when there's consummation of a conversion and the limited partner possesses the right to vote. The real and single dispute in this case is about whether the trust, the appellant, had the right to vote on the proposed conversion. But you have to keep reading Section 2114 because it effectively answers the question. The statute contains a provision saying who does not have the right to an appraisal. And that is somebody, a limited partner who is a partner in a partnership that's on the New York Stock Exchange or one that has over 500 partners. In other words, there are some details. Those people don't have appraisal rights. And in Section 4, the statute says a limited partnership can modify, restrict, or even eliminate the appraisal rights in the statute. But that hasn't happened here. And there was a lot of focus in the trial court, in the defendant's motion practice, and in the order on appeal on some language in two provisions of the 1994 limited partnership agreement. But those are just general provisions saying that the general partners' votes shall be final and saying that the limited partners should have no right to participate in the business of the partnership. And that's nothing special. That effectively just defines the nature of a limited partnership. And they would have had to have been prescient in 1994 to put something in that agreement that addressed something that didn't even exist in the law at that time. These appraisal rights were created in 2005.
Yeah, counsel, assume for the sake of my question that I agree with you and that we're not looking at the actual partnership agreement because of the statutory overhaul. Could you address 620.2103 sub 1? This is the one that says that a plan of conversion must be consented to by all of the general partners, which this one was, and also be consented by the limited partners who own a majority of the rights to receive distributions, and this one was. So in this particular instance, if we look at 620.2103, I think your colleague would say that a reasonable interpretation of that statute is that your client had no right to vote under 620.2114 sub 1B. Could you address that for me, please?
Yes, just because the consent has to be by a majority doesn't mean that the minority doesn't get to weigh in. I mean, how do you know that you have a majority, but it all has to be presented to all of them? And I think it's important to look at the
Where in the
notice.
statute does that come from?
To answer your question about 2103, one has to look at 620.2116, which is the notice provision. And it says there's two ways in which these appraisal rights can be, in which limited partners can be advised about a potential conversion and resulting appraisal rights. One is by a formal meeting, and that didn't occur here, and it didn't have to. But under subsection 3, if the appraisal event is to be approved other than by a partners meeting, the notice has to be sent to all limited partners at the time that consents are first solicited, whether or not consents are solicited from all limited partners. And that's essentially what happened here. They decided they
How
had enough.
How is there an appraisal event if under 2103 your client didn't have a right to vote because it was done by consent? I mean, I think we agree that consents and votes are different in the context of partnership, correct?
No, I do not concede that. I think it's very important to understand that a consent is just another way of tallying who's in favor. In other words, if they didn't have enough favorable consent votes, they couldn't have completed the conversion. And in fact, section 2117 even uses the term consent vote. That's a term in the statute. It's, I heard on the news this morning that Congress passed an important civil rights action by unanimous consent, and that it triggered something in me because it was a vote. They all agreed. It was unanimous consent. There's nothing different about consent and vote and approval. They're all effectively the same. And I think the attempt by the appellee and in the order to make a distinction is distinction without a difference, quite honestly. A consent vote is a vote.
I want to follow up on Judge Traver's question because it's mine as well. And I understand your argument regarding 620.2114 that the right to vote is limited in the sections that follow. And we understand why you may not give the right to vote for minority interest on the New York Stock Exchange, something like that. But I still don't understand where you ground on a statutory basis the right to vote for every limited interest holder.
Because for one thing, notice has to be given. I think the notice statute 2116 is key. If they are not excluded from voting, and no statute excludes them from voting, and nothing has ever been amended in the partnership to eliminate the right to vote. So you have to assume they have the right to vote, and they certainly had the right to notice, at which point, even if the general partners and the majority of the limited partners believed otherwise, at that point, at the very beginning of the process, the minority limited partner could have said, no, I have an interest in getting out at this point because I don't want to be part of the LLC, and I'm going to invoke my appraisal rights that were created by the statute. And they completely squeezed him out. And if you were to construe the statute otherwise, no limited partner would ever have appraisal rights. That's the irony here. And the only partners that get appraisal rights are the ones that don't consent, because the statute says that if you do consent to the conversion or merger, you don't get an appraisal. So who does under their construct?
Well, I mean, I think that's a policy argument as it relates to how we construe the statute. But I mean, if we just look at 2103, it would seem that the answer to your question is the limited partners who don't get notice or a right to vote would be ones who don't have a majority of the right to obtain distributions.
No, every limited partner, and I'm quoting 2116 when I say that all limited partners get notice, even if their vote's not necessary, even if their vote's not being solicited, because everyone already knows that they can't override the majority. So their vote may not be solicited, but they have no fewer rights than any other limited partner. They all have the same right. It's just that when a majority of them decide to go the same way, it's unnecessary to solicit the vote of the minority member or the minority limited partner. But that's exactly the point in which appraisal rights are ripe, so to speak. And at that point, the statute also provides for certain time periods in which you have to do, the partnership has to give the limited partner some financial information, the limited partner has to respond, and the process starts at the beginning. They did this backwards by completely squeezing him out of the deal, and nothing in the statute suggests that they can effect a conversion without notice to every single limited partner and without providing appraisal rights to one who did not consent.
That last statement seems very predicated, though, on the notion that we read consent and vote as co-equal, correct?
Yes, I think, the terms are not defined in the statute. And I think that the easy way to answer this is that there are two ways that you don't have the right to vote on in this, one way or the other. And that is either by statute or by contract. They had the right to amend the partnership agreement at any point under 21144. They didn't do it. They don't fall within the exclusions that are in the statute. And so therefore they had the right.
In common parlance, do you agree with me that there's a difference between consent and vote?
I'm sorry, I didn't hear the first part.
In common parlance, if we're just talking about an undefined statutory term, do you agree with me that there is a significant difference between me consenting to something and me voting on something?
Maybe there's some formality that's the vote it invokes or evokes, but they recognize in the statute that you can do it one of either ways. You can have a formal meeting, or it provides that if there is no formal meeting, here's how it's done. Because they know that these partnerships, limited partnerships, are often made up of just a few people. These are family people. And if you look at the testimony of Susan, in the main interest holder here, she said, did we vote? We got together. Did we hold up our hand and say, okay, if that's a vote, yeah, we voted. So nobody is applying this. The legislature did not, and nobody here is applying the terms in any kind of formalistic way. You have a right to be heard is the point.
Ms. Pohl, so are you saying that any reference in the statutes to the word majority or minority should be given no meaning? Is that what you're saying?
No, not at all, because you don't know if you're in the majority or the minority until after the vote, frankly.
Well, but as far as the notice goes, that's irrelevant based upon your argument, from what I understand. So we should effectively give it no meaning. Is that what you're trying to say?
No, everybody gets notice. All limited partners get notice. And the reason for that is if somebody doesn't want to consent, they are then on notice that it's time to invoke the procedures that the statute has for establishing their appraisal rights. And there may be a question even at the beginning of the stage, and the statute provides for a lawsuit that can be brought at that beginning stage. We couldn't comply with those time limits because we didn't know. No one gave us notice, and we couldn't do certain things within 90 days or however it is. But yeah, you don't know that you're in the minority.
Shifting gears for a moment, and obviously my question, because it's about attorney's fees, is going to be grounded in an assumption that you disagree with. But provided that we don't see it your way on this appeal, is your argument in your response to their motion for attorney's fees that we don't have the power to grant the motion, or that we should exercise our discretion to deny it?
I'm having to think back because, frankly, I didn't expect to be talking about attorney's fees at this stage. But I think that they have to show some level of misconduct or malfeasance, something.
Yeah, it's vexatious, arbitrarily, or not in good faith. And there's
really. And how can one
Yeah, there's not really any facts that are attached to their motion. And they asked that it actually be conditionally granted based on what the trial court does. But the argument that you make is different. Well, you make that argument, but you also make an additional argument that it's the trial court's exclusive province, I think, to decide this. I guess by inference that perhaps we're not a court in an appraisal proceeding, and the business court in Orange County is. So I wondered if your argument was a jurisdictional argument, like ones in perhaps like probate or guardianship, where the exclusive province of somebody to grant this would be the trial court.
No, frankly, I'm sorry, I'm not entirely prepared to discuss the attorney's fees issue. I don't want to confuse this with another case, but is this the case where they did not cite section 5946?
This is the one where they just cited the statutory right in chapter 620 about vexatious, arbitrary, or not in good faith. I'll tell you what, I'm going to ask Mr. McGee about it, and then we can get back to you about it in rebuttal.
Okay, which I believe that statute doesn't talk about appellate fees. And
that's what I'm getting. That's what I'm getting at, and I'll get back to you on rebuttal as to whether your argument is a jurisdictional one.
Ms. Cole, you're into your rebuttal time, so I don't know if you want to.
Okay, well then I will get back to you on my rebuttal time.
Thank you.
Thank you.
Mr. McGee, you may proceed.
Thank you and good morning. I'm Patrick McGee. I represent the Applee Christensen Family One LLC, the company here. To set some context, the trust's single count complaint described its cause of action as a statutory limited partnership appraisal case pursuant to section 620.2114, and the remedy sought by the trust was the right to an appraisal of its interest in limited partnership and the payment of that amount in cash. Many of the arguments of the appellant here depend on using the concepts of a right to vote and appraisal right as interchangeable. But these are two quite distinct concepts and are in no manner interchangeable. The citation by counsel of what she refers to as the critical notice statute in 620.2116 being the key, and that all limited partners are get notice. But 2116 begins with if a proposed appraisal event is to be submitted to a vote, and subsection 3 talks about if the appraisal event is to be approved by other than at a partners meeting, this notice goes out. So it's really putting the cart before the horse here. There's no appraisal event that occurs without the right to vote. Appraisal rights, which are rights that flow when an appraisal event occurs, are potentially available when a limited partnership changes its form of entity, but the conversion itself is not an appraisal event. Chapter 620 requires more. As to the trust here, the conversion could not have been an appraisal event unless the trust possessed the right to vote upon the conversion. And under the statutory definition of an appraisal event in the context of a conversion, an appraisal event can occur only when the limited partner possessed the right to vote upon the conversion. The trial court here was right to conclude that the trust failed to establish that it possessed the right to vote upon the conversion, and therefore that no appraisal event had occurred. Without that right to vote, there could be no appraisal event, and without an appraisal event, the trust had no entitlement to the statutory appraisal rights that it was seeking. So to be clear, the partnership agreement here limits the right to vote as to limited partners, and it does so by not granting limited partners the right to vote on anything. At the time this partnership agreement was entered into, there was a statute, 620.133, titled Voting Rights of Limited Partners, and under that statute, the limited partnership had the option in its partnership agreement to grant limited partners the right to vote on any matter at all, but it didn't do so. So without the right to vote, a limited partner such as the trust would not have appraisal rights under the fact of this case. Our trial judge noted that in his order, where in citing the amendments and the addition of appraisal rights in 2005 and the arguments by the appellant in this case, that it's the partnership agreement did not restrict appraisal rights. really the point is whether the partnership agreement allows voting rights, because the voting rights cannot be found in Chapter 620. Partnership agreement does not allow a vote by the limited partners on any matter whatsoever. So that's really the linchpin in this case of showing that you don't get to appraisal rights without showing the right to vote. And I would disagree with counsel's reading of section 2114, where the analysis is that subsection 2 states those classes of limited partners that do not have appraisal rights. There's a distinction here between having voting rights and having appraisal rights. And 21142 references that notwithstanding section 1, the availability of appraisal rights are limited to the following classes of parties. So section 2114, the subsection 2, the exceptions that are carved out there are as to those limited partners that already possess the right to vote upon the conversion. But even with that right to vote, subsection 2 carves out certain categories of limited partners that nevertheless do not have appraisal rights. And the same with subsection 4 of that same statute, 2114. It provides that a partnership agreement may modify, restrict, or eliminate appraisal rights. It does not refer to voting rights at all. It presumes that a limited partner already has voting rights and therefore has appraisal rights. So to use these terms of voting rights and appraisal rights interchangeably distorts what the process is under Chapter 620 for conversions and appraisal rights that potentially can flow from that. And the assertion that under the trial court's interpretation of the relevant conversion statutes that no limited partner would ever have the right to vote, there are instances where a partnership agreement can delegate management powers or vest limited partners with certain rights. Section 620.13051 relates to just such a circumstance. And if the partnership agreement grants management powers or duties to a limited partner, including the right to vote in general or the right to vote on a conversion, well, under those hypothetical facts, an appraisal event could occur if there was a proposed plan of conversion. But we don't have that here. Our partnership agreement has no voting rights for these limited partners, and therefore we never get to the point of whether there are appraisal rights. And none of the exceptions apply. This is not a conversion to, for example, a general partnership where the limited partner would then, after the conversion, have some sort of individual or personal liability. The conversion plan and the consents would be ineffective under those circumstances. We have the same entity for all intents and purposes, and that's provided for in Florida statutes, same entity before and after the conversion as to assets and liabilities. So the notice provisions that council refers to are notice in the event of an appraisal event. The conversion itself was not a scheme to abuse the trust. There was no valid reason for continuing to operate a real estate holding company as a limited partnership under which the general partners have individual or personal liability for what occurs on the various properties. But nothing in Chapter 620 required the trust's vote or its consent for the conversion to occur. Chapter 620 called for the mere consent of all the general partners and a majority of the limited partners, all of which could be obtained under Chapter 620 without a meeting of the partners. That's what occurred here. And with the consents in hand, the plan of conversion complied with the process set forth in Chapter 620 and was lawful. There's no additional right to be heard or right to notice of a limited partner whose consent was unnecessary for the plan of conversion to comply with the process in Chapter 620. So we respectfully request the court to affirm the trial court's conclusions, both granting the summary judgment in favor of the company and denying the trust's request for summary judgment relief. I'd be happy to answer any questions that the court might have. Otherwise, I would relinquish the remainder of my time.
Yeah, my questions are about 620.2123. Are we a court in an appraisal proceeding for purposes of that statute?
I would think so, Your Honor. We have an appraisal case and you're a court.
The statute talks about a finding that we make, and I think you'd agree with me that we're particularly ill-suited to make factual findings as it relates to vexatiousness, arbitrariness, or bad faith. I note that you have a pending motion in front of the trial court, but that in neither that motion nor in the one you filed with us, there's really any detail in there about why the opposing party acted arbitrarily, vexatiously, or not in good faith. So first for me, would you address our ability to make a finding, if at all? And then secondly, if you would address what, if anything, in the record provides the basis for that finding?
Yes, Your Honor. The standard for our position is a standard for granting attorney's fees on appeal under that statute with the vexatious, arbitrary, lack of good faith would be the same standard in this court as it is with the trial court, and that the trial court is suited to make that type of a finding. And it can be an evidentiary hearing where the court would make that determination. As far as the record basis of filing a lawsuit without the, in this case, vexatious, arbitrary, lack of good faith, it is founded primarily on the fact that the plaintiff alleged that it possessed the right to vote upon the conversion, and it did not. It's not in the partnership agreement. You cannot point to a section of section 620 that grants the right to vote to the appellant in this case. And
yeah, this is what I thought. This is what I thought that you would say, that the arbitrariness or vexatiousness is grounded entirely in their interpretation of the statute. I struggle because there's no case law interpreting this particular statutory provision. So I try to look at it in tandem with 57105 or 9410. Do you view vexatious, arbitrary, and not in good faith as a higher burden, or a lower burden, or an equal burden to 57105 frivolousness?
Well, like counsel, I was not prepared to respond to this, but I will tell you, just based upon my experience, I would consider it a lower standard, that the trial court can find that that a party acted arbitrarily or vexatiously without making the findings that are required for 57105 fees.
I mean, for us, in terms of appellate fees, we have Rule 9410, which requires a safe harbor letter, a specific identification about what in the case is frivolous. It seems in those situations that perhaps you're right in the sense that there's nothing like that required for this particular statute. However, I do struggle with the idea that something could be vexatious, arbitrary, and in bad faith based on a statutory interpretation and somehow not be frivolous under 57105 and thus merit the safe harbor provisions and all of those other attendant protections under Florida law. Do you have any reaction to that?
Yeah, I appreciate the distinction that the court is making. However, if a party claims to have a right to take these actions under the statutes, and what they are citing as far as the notice they are to receive are notices that apply only when an appraisal event occurs, or they cite in their brief, for example, that what they're entitled to by statute, and this is on page 7, for example, the reply brief, is the right conferred by the statutes is the right to notice and to be heard. And if the consent is not given to appraisal rights, there's no statute that this party can point to where it says this is where we have the right to vote. This is where we were granted the right to vote. And without that, I don't know.
What do we make then of like Florida jurisprudence, which is a pretty widely accepted treatise, seems to conflate the idea of an appraisal event and conversion and reads them interchangeably. So, I mean, at least there's something out there that would be supportive of the position that they're taking other than the seemingly logical points that your colleague was making during her time on argument.
Well, if there is such a blurring of the lines between an appraisal event and the right to vote upon an appraisal event, I've not seen it.
It's cited in her brief. It's cited in her brief, and
is this the Lou Conte article that the court's referring to?
No, it's the Florida jurisprudence section on appraisal rights.
Yes, Your Honor. I think if you're down, I'm not a fan of citing Florida jurisprudence ordinarily.
Be that as it may.
Like to see the authorities on which that statement is made. But I think unless you can point to a statute and say, here's the statute where my voting rights were granted, so that the plaintiff here was entitled to vote upon the conversion. I don't know that the claim to statutory appraisal rights is made in good faith. I don't know that it's a statutory interpretation. It's the absence of a statute in its entirety.
If we grant your motion for fees, do we necessarily then make the trial court's work a fait accompli? We've already made the finding. They're bound by it.
I think to the extent that the court's finding would require an evidentiary determination, that should be remanded to the trial court because it's the same evidentiary interpretation. So it would be conditional upon the trial court finding that this action was filed vexatious, arbitrary, lack of good faith.
Well, I mean, in that sense, and you do ask for that particular relief, in that sense, would you be basically saying that it's not within our province to deal with it right now? We should deny it without prejudice for you to seek the fees for this conversation that we're having right now in a later evidentiary hearing before the trial court?
In essence, yes. I think there might be a couple of different ways to do it. I think it can be granted conditionally upon the trial court making a finding that the complaint was filed within the parameters of the statute that allows attorney's fees to be assessed. Vexatious, arbitrary, lack of good faith. I doubt that the court would make an evidentiary determination. If the court determines that the request for relief without an evidentiary determination or without the going beyond what we've just talked about here is insufficient, then that would be something different. But I think it would be appropriate for the court to remand conditional upon there being a finding of the trial court of vexatious, arbitrary, lack of good faith, subject to whatever appellate rights that the party might have for that court ruling.
Thank you.
Mr. McGee, I have a question, also a follow-up question to Judge Travers' questions about vexatiousness. I was looking for a definition of that anywhere and couldn't find anything. So I guess I reverted to the old Webster's citation. And it appears to me that it talks about tending to cause annoyance, frustration, or worry. That appears to me to focus entirely upon your client's reaction to whatever action or remedy that the appellant would be seeking. That appears to me to be an incredibly low standard as far as what's the threshold for your client if you apply that reasonable definition. Is that what we're talking about here?
Well, it may be. One of the circumstances that we have involved in this case was that the lawsuit was simply filed. This lawsuit and another sister lawsuit was simply filed without any communications between the family members, and there had been years of efforts by the trust, formerly by Frederick Christensen before the interests were put into the trust, to separate himself from the partnership. So
but isn't that an entirely, that's a very subjective standard, correct? The trial judge is basically supposed to assume the position of your client and whether or not your client is annoyed with regard to the appellant seeking any type of legal relief.
That does not seem like a high bar, Your Honor.
Okay, thank you. All right, I think, Mr. McGee, you've rested?
We have, Your Honor.
All right, Ms. Pohl.
Yes, frankly, I'm shocked that we're having this discussion about fees for the appellee because on the merits, the result that the trial court drew, basically adopting the appellee's position, is so contrary to the statute that I'm sorry that I can't seem to convey that. Appraisal rights were newly created in 2005. You can't look to a 1994 agreement that says nothing specific about appraisal rights and just says a limited partner can't be participating in the conduct of the business. We know that. That has nothing to do with a newly created statutory right in 2005. And the legislature said, hey, if you don't want to give your limited partners appraisal rights, you can amend your agreement, and modify or eliminate those rights. You can't look back to terms that were in a 1994 agreement. This right was created for any limited partner who does not consent to a conversion and who is not excluded by statute or by contract. The trust falls within that definition, and it absolutely had a right to notice at the very least, and now, because the appraisal was completed, a right to invoke its right to an appraisal. And that's pretty simple. I think the appellee has overcomplicated it by trying to make this distinction between an appraisal event and who can vote and this and that. It's quite simple, actually. Every limited partner who does not consent has appraisal rights unless they're excluded. The trust is not excluded, and it has those rights. But if we are going to talk about vexatiousness and arbitrariness, let's point out here that the statute requires notice to all limited partners, and they absolutely ignored that statute when they did this without kind of any notice at all to the Frederick Family Trust. Even after the conversion had occurred, they wrote him a letter on letterhead.
If you'd have moved for fees,
which didn't even exist anymore.
Hey, counsel, if you'd have moved for fees, and let's go with that line of inquiry, and we were inclined to grant it, would we basically deny without prejudice for the trial court to figure it out and make specific findings? Or would we grant it based on your correct interpretation of the statute and then effectively make the trial court's determination below either moot or a fait accompli?
You would grant it, and the trial court's role would be to determine the amount at the conclusion of the case. Because if we win this appeal, the underlying case is not over. They would then have to determine the amount that's owed as an appraisal. After the appraisal, there has to be valuation done of the partnership's interest in the.
But you're saying that statute gives us the power to make a finding of vexatiousness just purely based on the statutory arguments that are made?
I don't think you have to make vexatiousness to award fees on our end. I think the vexatiousness only applies.
I mean, we can't award fees on your end because you haven't asked for it, but
we moved for fees. We moved for fees.
Okay. I apologize if I missed that.
Yeah. That's my greatest fear, is forgetting to move for fees.
No, you absolutely did. I apologize.
Yeah. But under the standard for our prevailing, all you have to show is that they didn't act in accordance with the statute. And the record before this court shows absolutely they didn't act in accordance with the statute, but by denying us any notice in advance of the conversion. I know I'm running out of time and I just want to wrap up, but I don't think you have to work so hard to compare terms and be quite as persnickety as the appellee is saying. I think you look at 2114 and you say, are we excluded from appraisal rights? No, we are not. And did they take the opportunity anytime since 2005 to amend the partnership agreement? No, they did not. And in that case, we have the right to vote and we have a right to an appraisal. This court should reverse.
All right. Thank you, counsel, for your arguments. It was a well-argued case, and we stand in recess. Have a great day.